It is Morning in America. Welcome back. We're delighted to have David Rivkin back with us. If you have questions about legalities here, what's legal, what's not in this whole mess, can't think of anybody better of whom to ask these questions than David Rivkin. He's a partner at Baker and Hostetler. He served in the Justice Department during the Reagan and George H.W. Bush administrations, not the Eric Holder administration. I want to get to that, too. I'd like to get to the Holder administration, the recusal. I'd like to get to the press thing, but I want to start with IRS because of your brilliant article, you and Casey. Thanks very much, David, for joining us.
Good to be with you as always.
Did Lois Lerner waive her Fifth Amendment right yesterday by her opening statement?
I believe so. She specifically said, Bill, that I've not broken any laws. The only basis for invoking the Fifth is if you have a reasonable fear of being prosecuted on the basis of the statements you're going to make or questions you're going to answer. It's not enough that you might be embarrassed. It's not enough that people might think ill of you. So given her unequivocal statement, I don't see how she can properly invoke the Fifth Amendment.
I heard several lawyers yesterday speaking seemingly with great authority, not with your thoughtful tentativeness there, but saying, oh, absolutely not. I heard two lawyers say, and a couple were quoted in the Post this morning, this is not a court of law. This is a congressional hearing, and so the rules are different.
That's not true. Whether or not, even the court of law in a congressional hearing, the basis for invocation of the Fifth Amendment privilege is exactly the same. In fact, what I predict is going to happen, the committee is going to ask her to come back and testify. She's going to refuse. They're going to hold her in contempt.
Oh, okay, because I think yesterday said, if we narrowed the scope, would you accept that? No, the answer was, or same thing on advice of counsel. So now he brings her back. Will he say, I'm bringing you back on grounds that you did waive your privilege?
I believe so.
And then
that's certainly what I would do if I were there.
Okay.
I would send him a letter. I would send her a letter saying you waived the privilege. You made an unequivocal statement. And let me be clear. It's the fact that she said, I've not broken any laws. If she had
right.
anything wrong morally or ethically, if her statement was more equivocal or ambiguous. But when she said, I've broken no laws, and she went on to say no regulations, I don't see how she can invoke the Fifth Amendment.
Okay, I understand that. If her lawyer maintains, as he will, Taylor, that she didn't, is there somebody to settle this? Can this go to? Can ISIS say, let's get this settled in court before we call you back?
That's exactly, Bill, how it's going to happen. Congress is going to hold the House is going to hold her in contempt.
Okay.
And then, as a matter of comedy and longstanding practice, because of course it's the executive branch that typically does that. She will be then held in contempt, and she can challenge that in court. And I believe, I can't imagine even in this administration, the DOJ would not drive these proceedings. In some exceptional circumstances, if you hold a high-level government official in contempt, then Congress would get his own lawyers.
So the sequence, I may ask you to repeat some of that. So they call her back, they ask her questions, she refuses to answer, they hold her in contempt, then she leaves, and what happens?
The contempt citation would be enforced by court, and again, the normal process would be for that to be done by DOJ, by the U.S. Attorney for the District of Columbia. In very few instances where let's say if you hold Holder in contempt, since it would be unusual for DOJ to be prosecuting the Attorney General, then Congress can get his own lawyers.
All right. But
she will go to prison. She'll go to prison and will be held there. That's how contempt works.
Okay. And you don't think DOJ would play funny games on this one?
I think it will be difficult for them. It's really a straightforward matter.
All right.
Because can I tell you one thing, Bill? It would be different if it's a matter of invoking executive privilege.
Okay.
President ordered me not to do that.
I see.
cetera, et cetera. So what would be the basis for DOJ not to do that? It's
all right.
very much run-of-the-mill stuff.
All right. I don't want to strain the soup too thin here, David, to try to get too much out of this. But do you think, before we get to the general IRS question, do you think that what she did yesterday helped the president or not?
No, I'm surprised. I don't know her. I don't know her lawyer, but I'm frankly stunned that she proceeded in this fashion. I understand she doesn't want to answer questions, but and this is the problem. She's trying to have her cake and eat it too. She's trying to win in the court of opinion by saying I've broken no laws or regulations, and yet not answer questions. Forgive me, that's not how it works.
Yeah, I don't think she won a lot of fans yesterday, and people will draw their own conclusions. And ISA reminded everybody, don't assume anything from this, but the whole world is watching, and we're not a jury, and we can say that's ridiculous. So, we draw our own conclusions. We're allowed to do that in a free country, right?
Absolutely. Krauthammer put it well a couple of days ago, and the jury's not supposed to draw any inferences, but the people certainly can. Look, if she's done nothing wrong, I cannot think of any reason for her not to testify.
Yeah. Okay.
They should be anxious to get her story out.
That's great point. Okay. If you want to talk to David Rivkin and me, or just David Rivkin, that's fine. 866-680-6464. Your piece is what the IRS did, as far as we know, illegal?
Yes, but let me clarify. First of all, IRS supposedly, allegedly, but most likely, certainly, done three different things. One of which is clearly a felony. That's the release of confidential tax information.
Okay.
Media stories that reveal confidential tax information about conservative groups. That is a felony.
Is this the release to the ProPublica group?
Yes.
Okay.
And that's it's federal law. Now, the two other things that they've done, it gets a little more complicated. Scrutinizing excessively requests for tax exemption by conservative groups, or improperly auditing them, and improperly in the sense that you're auditing them without a good basis. And likewise, Bill, disproportionately auditing conservative donors and activists. Those things are, certainly in my view, violations of the Constitution, and may well be a basis for a lawsuit against the government, provided you can get for some immunity issues. I don't think, under the current law, they're a basis for imposition of personal liability on against officials involved.
What's the constitutional equal protection of the laws?
Equal protection, but also serious infringement of, we argue in our piece, serious infringement of the First Amendment rights. We're talking about suppressing political.
I see.
It's a classical speech-suppressing activity by the federal government that is very much unconstitutional and very troubling.
Okay, and all right. So these groups can bring suit, and I guess are bringing suit. Some of these groups, right? Is that right? And could prevail.
Some of them are bringing suits. As I said, there are challenges, in terms of proof and various other things. But yes, but look, fundamentally, this is something, as we argue, that arose not only of some political ideology of this administration that's very hostile to Citizens United, which is the major Supreme Court decision unshackling political speech by corporations, very hostile to Tea Parties, and by the way, not only Tea Parties, they've done it also to religious groups, from what I understand.
Right.
It's enormously troubling, and remember, they've done that very much in the context of upcoming federal presidential elections. So it would have been troubling any time you do that. This was done in particular in the election year.
Have you been following the hearings other than Lerner with Schulman and Miller and all?
Yes.
What's your sense of them, of that? Is there liability there on their part? I mean, they're dodging every question.
Well, and thank you for asking me. There's clearly, as with many Washington scandals, I think a number of people are in trouble because of they committed, and put it very bluntly, I believe they committed perjury. Congress is not a good thing, and this is now not just civil contempt. We're talking about criminal prosecutions. I mean, I don't look. Some of these people, including both of the former IRS commissioners, from what I understand, now I've not read their previous testimony, Bill, but from what I understand, they were crisply asked whether or not there was any targeting, and they said no. And, of course, there was, and, of course, they now know what they knew about it.
Yeah.
That's a classical perjury. I mean, this is not just, I was not forthcoming. And, Washington history is replete with examples of people who went to prison for lying to Congress.
Partner at Baker and Hostetler, served in the Justice Department during the Reagan and George H.W. Bush. Quickly, Eric Holder recusing himself in this AP case, but not writing it down. Does that matter? Can't remember when. Does that matter? Is the recusal unusual?
Recusal may not be unusual if the reason for it, as it appears to be, Bill, that he was himself investigated in connection with this leak. But let's focus on the big picture here. What's enormously unusual is this administration engaging in overly broad, investigative practices pertaining to journalists. I'm all in favor of investigating national security leaks, but you proceed against 1, 2, 3 journalists. Keep it very narrow because of First Amendment considerations. Apparently, they went after dozens of AP reporters for a period of months, and that's overly broad. And the fact that they don't see a problem with it just underscores how arrogant and disinterested in the Constitution they are.
What I asked, and a lot of our listeners asked, is, okay, he's recused, recusal, he's out of it, so you go to the deputy. Why hasn't the deputy been up there to answer these questions?
Absolutely good question or good observation. And the point for your listeners to appreciate is precisely because trampling on the First Amendment rights of the media is so consequential that it has to be done. It being any approvals for subpoenas directed to journalists or their phone records have to be approved at the highest level of the department, either the AG or the deputy. It cannot be done on purely the U.S. Attorney level.
So you expect we'll see the deputy up there on this?
I do. I think Congress would invite him to testify. In fact, one thing that's not clear is what was the chain of command here, because Holder hasn't clearly explained. Okay, I'm accused. I suppose there can be circumstances you can give it to the number 3 person, Associate Attorney General. But
okay. Well, we may find out when we talk to number 2 that he recused himself. Right?
Yes.
Okay, and then we'll go to number 3. We'll keep going. Back to IRS. We played earlier in the show, David, audio of Democrat Congressman Stephen Lynch from Massachusetts, and said, if you guys continue to be so uncooperative, we're going to probably have to do a special counsel. Is that a good idea? What's the difference between a special counsel investigating it and the committee?
Well, they're totally different approaches. A special counsel is part of the executive branch, and what you're doing is you're creating a special investigative channel because you think it's a scandal that touches upon senior administration officials. Normal investigatory channels are not adequate. I don't quite understand why there's a trade-off here. Congress has its constitutional responsibility to investigate. The executive branch also is supposed to investigate, and this certainly may well be appropriate to have a special counsel. Remember, we don't have independent counsels anymore, Bill. That statute has expired, not been renewed. But I don't understand the trade-off between congressional investigation and the special counsel investigation.
Oh, you mean you don't understand why they would want a special counsel?
Oh, why they're suggesting that if you wish to have a special counsel.
You mean it's either or? You can do both.
Yeah, and you should do both. Two co-equal branches have different responsibilities, different roles. So perhaps you were suggesting, Bill, that if he's uncooperative, that makes it impossible for administration not to proceed with special counsel. Yeah,
I guess so. I guess that's what I was suggesting, yeah. But a lot of people would be chary of the suggestion that, we have a special counsel that's appointed by the executive branch. Is there grounds to worry about that?
Well, I mean, despite all the problems with Holder's DOJ, I'm a big fan of DOJ. Lots of excellent career people.
Okay.
I think that an appropriate career person would investigate this vigorously.
Okay, fine. I'm going to leave it there, and then if you will stay, we got a ton of questions for you. I've asked the listeners to hold on.
But I just make one quick point.
Please.
As compared with AP, as troubling as the AP story is, the James Rosen is even more troubling. And what's particularly troubling is the administration bill seems to be now articulating an argument that they can indeed go after reporters, provided reporters do, let's say, vigorous news gathering. So it's okay. I don't know if you've seen that there's actually a blog post by an anonymous administration official saying, well, Rosen could have been charged for spying because he didn't just sit in his office and wait for classified information.
Right. He was aggressive.
He went vigorously after it.
All right, we got to pause there. Roger is in Washington, D.C. Go ahead, Roger.
Hi, good morning. Thank you very much. I'm an attorney. I know nothing about the RICO law, but in the half-hour research I did, I see that there are cases where the United States has been held to be an enterprise. My question is, given that there is, in my view, appears to be a form of conspiracy to break election laws, et cetera, that violate constitutional rights, could this not be prosecuted against certain employees as a RICO action?
Yeah, it's a possibility. It's an interesting possibility. It would have to be a civil RICO action, of course, because only the government can bring criminal charges. But yeah, it's a tough statute. There are lots of elements you have to satisfy, but it may be possible.
Thank you, thank you, Roger. Steve in Atlanta. Go ahead, Steve. I want to piggyback on your question.
Yes, in regards to the questioning before Congress, Attorney General Holder and the IRS people, and them being smug and condescending. Why shouldn't they be smug and condescending? They have the power. They don't care what Congress thinks. They don't care what the people think. They've got the power, and they know nothing's going to be done to them.
Yeah, let me piggyback on that, David. It's not a legal question, but I'm interested in your opinion because Congress has certain legal powers and responsibilities. But clearly you can see from testimony yesterday kind of indifferent responses and, well, what did you ask me? And I'm sorry I wasn't listening to you. Holder snapping back at ISA. Clearly these guys are reading the ratings of Congress and the view of the American people, and they're in very low standing. And I think they can get away with more. So in the spirit of Steve's question, they're saying, to Congress, drop dead, and they may get away with it.
Well, I hope we would not get away with it because, again, we're talking about the most fundamental warping of checks and balances. Look, I spent all my professional career working for the executive branch. I'm usually sympathetic to the executive.
Yeah.
But Congress is an essential part of a system of checks and balances. Unbridled, unshackled power is very bad for individual liberty. Look, quite frankly, I would say this to you and the listener. Let's look at the public opinion. If the president's, and I hate to be somewhat cynical here, but if the president's approval ratings hold up, then indeed they may get away with it because I don't think that trying to impeach Holder is going to work, particularly given the fact that the Democrats control the Senate. But if American people is upset about this arrogance, disdain that they display, and his ratings go down in the 40s and in the 30s, I think that a number of Democrats would abandon him. I frankly don't think the president is very popular with members of his own party, precisely because he treated Congress as an institution with disdain. Look, we're talking about straight. Yeah. I mean, if we had a couple of hours, we can go on through all of it, that rewrites laws, that does not bother to work with Congress on anything, that his most imperial presidency, makes Richard Nixon blush wherever he is in right now. So he does not have much of a staying power if his popularity goes down.
Yeah, so far you have a split decision on this. The American people, I was surprised to see how seriously they're taking these scandals. I was glad to see it because they're very serious, I think. But they're still holding him way above water.
Which is, and by the way, one other point that depresses me deeply, this total, in effect, a professed disdain for accountability. This is the president who's basically saying publicly and privately, what me? I did not know. Yeah. You are supposed to know that one of the overarching constitutional virtues is accountability. The American people need to know what part of government, state or federal, Congress or the executive, which department is doing what to them, and the buck stops the president. This is the president that takes the position, I'm not supposed to know anything. That's not my problem. That cannot be.
Well, not supposed to know anything except things that, bring credit on himself. He knows about those things a great deal.
I agree.
I served 2 cabinet-level positions, and the one thing I'd, say about some of this testimony, this notion of not telling, anyone in the White House is just crazy because, the rule was, I had a rule when I was secretary, when I was drug czar. I don't want to be surprised by something going on in here. Tell me. I want to know. I don't want to read about it in the paper.
That's exactly right.
And the same thing in the White House. Every chief of staff would tell you, we want to know. Let us know what's going on.
Well, I don't have hard proof, Bill, but I suspect the overarching sort of policy guidance for senior people in this administration is to not tell the president anything that might be politically dicey because he wants plausible deniability. This is wrong as a matter of management, but what I want to emphasize for your listeners, this is wrong as a matter of Constitution. Framers created a unitary executive precisely to ensure not only vigorous executive, but accountable executive.
Yeah.
Because it's unitary. You cannot say, well, it was not me, it was my Secretary of Treasury or my Secretary of Labor. No, you are supposed to be responsible for everything.
Yeah, I'm remembering my Federalist Papers. Hamilton says the argument against the plural executive is, oh, no, it wasn't me, it was the other one. It was the other president. It was this president, it was that president. The unitary executive means it's clear where responsibility lies for the actions of the executive branch.
That's exactly right. So the American people can hold a person accountable for good things and bad things.
Yeah, that's right. For both. That's right. For both. Let's go to Bill in Cleveland. Go ahead, Bill.
Hey, thank you so much. Say, the special prosecutor can do his work quietly until after the next presidential election and brush the whole thing under the table. Are we better off with a select committee to have public hearings and to make these people answer 100 questions that I plead the fifth so the American people know what's going on?
Yeah.
I think we should do both. I think we should have a special counsel investigating this with the executive, and we should have a select committee. And again, it would be interesting to see which way the Senate Democrats are going to jump in the end of the day.
Would you have all three? I mean, would you have these committees continue as well, and select committee and special counsel?
Well, I think they certainly should. The committees of jurisdiction, Bill, should certainly investigate, unless and until a special committee is created. Once such committee is created, it might be a little bit of an overreach to have 3 or 4 committees in the House and the Senate doing it, plus a select committee. And the whole point of having a select committee is to sort of centralize and coordinate things better.
Yeah. Okay. Very good. David can stay with us a few more minutes. You have a question for David Rivkin. It's 866-680-6464. Doug is in Grand Junction, Colorado. Go ahead, Doug.
Good morning, guys. I had a couple questions. As far as the enforcement, when it comes to incarcerating someone, if she comes back, Lerner that is, and doesn't want to testify, and she's held in contempt, who makes the decision as to whether or not she's incarcerated? Is that a judge? And then also with Shulman, didn't Shulman, I don't know who he spoke before last summer, but was it before a jury? Didn't he incriminate himself by saying he knew nothing last summer, and then it comes out that he said there was no specific targeting of certain groups, which we all know there was. Isn't he somehow responsible for that statement?
Okay.
Yes, good question. Take the second one first. I certainly believe, but again, I'll be more careful. I'm not read the testimony, but it appears that he perjured himself. He would be prosecuted. Congress would refer this because, again, Congress is not does not execute the laws. The DOJ does. Congress would refer this to DOJ for prosecution. They will prosecute him for perjury, which is a felony, and he will be tried and then, I believe, convicted, and will be doing time. Not to put too fine of a point on it. As far as Ms. Lerner is concerned, again, this would be a referral by Congress to DOJ. Congress would seek to hold her in contempt, and she would be tried before a judge, and quite likely they end up spending time in prison for contempt. Of course, 2 different issues: contempt in her case, perjury in Feldman's case.
Okay. We had to cut you off earlier at the end of the last segment. You were talking about Rosen, the heart of the matter. If you can repeat that, because we did have to cut prematurely.
Thank you, Bill. It's very troubling. Here, the administration is actually articulating, although interestingly enough anonymously, articulating a basis for continuing in the future to proceed against journalists, and they're coming up with an utterly untenable position. They're basically saying the following: but if you are not doing anything actively to solicit receipt of confidential information, you sit in your office and suddenly somebody drops on your desk a package of classified documents. Okay, you're a good dog, you're a good reporter. But if you actually go out and you take people to lunch, you cajole them, you develop sources, you work them, and then you get confidential information, you're a co-conspirator. And therefore, we can prosecute you under the 1917 Espionage Act, and we certainly can go get a warrant application and get all of your personal records, not only your professional email. That is absolutely untenable position. Oh, and if you look, I would urge you listeners, it's actually on web now, to go read the warrant application signed by an FBI agent where they described Rosen as a co-conspirator. Guess what he did? He tried to induce the source to give him the information, and he tried to assure the source was not discovered. These people don't remember Watergate. Do you remember the business about the, using surreptition, how, I forget, it was Woodward or Bernstein who had a little plant out when they wanted to meet with it. Oh, and by the way, this guy, Rosen, gave a moniker, gave a name to his source. Have you forgotten about the deep throat?
Deep throat, yeah.
This is absurd.
Yeah, it's very interesting. Very interesting.
What they're trying to do, though, is they're trying to come up with a notion that we can regulate the gathering of news. We can regulate the reporter's business. And by the way, this is also nebulous and so touchy-feely. It gives them an opportunity to go up to conservative reporters in particular.
Yeah.
So maybe if your reporter gets classified information and puts the president in a good light, that's okay.
Yeah.
Get classified information and puts the president, and they write a story, puts the president in a bad light. Then you're a co-conspirator. You're aiding and abetting espionage.
All right. Very quickly, we got to let David go. David, other David in Louisville. Real quick, David in Louisville.
Yes, am I on?
Yeah, quick.
Okay. The low-level IRS agents, did they not break the law by, asking these questions and kind of singling out the conservatives? And would, integrity starts every morning in the mirror. When you look in the mirror, is there, do they not have a duty to report?
Okay. And do mid and higher level people have a duty to discipline them? We have about 20 seconds, David. I'm sorry.
Yes, the short answer is certainly acted in a way that violates the Constitution. I do not know right now whether or not they broke any law that makes them personally accountable. Probably not, and it's an interesting question. Should there be such a law that actually makes individuals personally liable for political targeting and abuse of power in this circumstance?
Brilliant, very helpful. Please stay close, David. Thank you.